Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party. At the hearing, all agreed that the sheriff's department is not a party in this case. The state and the sheriff's office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the sheriff's department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, of prejudice.
At Online Business School, we provide a unique pathway to a UK university qualification.
Is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial. Joint request to limit electronic media coverage, both restricting the recording of restraints strikes the proper balance to return before the court on January 16th, 2026 at 1 p.m. And again, the court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer on behalf of another set of media interveners also identified in the briefs.
Good afternoon, and I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues.
Hello.
The most important thing about a video is how it sounds, but finding the right audio can be challenging.
To the letter, the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restarted. So it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th.
We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our
it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants.
If you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted
of them being a limited purpose party, because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24
or what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records.
Will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue. And so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, or reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. They are looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay. And we're trying to find a date, because this is an important case, as is all of those cases. They matter to me.
Your Honor, to respond to these motions as timely as we can, as expeditious.
Present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and
This AI tool will create a stunning ebook direct from your content, whether it's a Microsoft Word document or
possible witness of the
Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights.
Not only the court, but all of you. What, first of all, how many days
Hearing, it is a problem.
that the parties have a lot of obligations, but I also recognize the importance of this case moving forward. And if nothing more than this is a goal for the preliminary hearing, if it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is